We're going to have a Retirement 101 program on November 17th. It'll be an evening program. It'll be talking about sale of law practices and other issues that senior lawyers start to confront as we start to age. And there will be the ever-elusive ethics credits. So mark your calendars for that. Announcements will be coming out shortly. There will be a program with the Appellate Courts Committee in January of 2011, and Judge Epstein, who's the presiding justice of the 4th Division, I believe, Court of Appeal, will be talking about a history of the Supreme Court. So that should be really interesting. John Marshall Day will be honoring certain trailblazers, Lee Edmond, who will be the first woman presiding judge of the LA Superior Court, and the late Sam Williams, who was the first African-American president of the LA County Bar and the State Bar. Before we get started, just some shout-out thank yous to some people who were very involved in this program. David Pasternak, where are you? Thank you so much for all your hard work. It was David's brainchild putting this program together. He arranged the speakers. He suffered through innumerable emails and telephone conferences with other volunteers from the section and LACPA staff. So, David, we are eternally grateful. Thank you so much. Hugh Bealey, the vice chair, who has done a wonderful job of helping put this program together. Marilyn Elper, our section program chair. Marilyn's in the back. And thank you also to LACPA staff, Sally Sucho, Clark Brown, Jason Isais, Marjorie Diaz, Cecilia Gomez, and especially Gail Coleman, our wonderful, tireless, and always cheerful, even in the face of dealing with all of us lawyers, section administrator, Gail Coleman. Gail, thank you so much. Thank you to all the staff. So this is the 3rd annual Frozen in Time program. Since we're senior lawyers, we thought that some historical programs might be interesting, and based upon the attendance tonight, thank you very much. There obviously is an interest in these kinds of programs. I think especially tonight, given the nature of the topic. Seth Huffstedler is our moderator. We're delighted to have you, Seth. Thank you so much. Seth is a former president of the Los Angeles County Bar Association, a former president of the State Bar of California, a former president of the American Bar Foundation, and I'm exhausted just thinking about all these things that he's accomplished. His biography and those of the other panelists are in your materials. And with that, I will turn it over to Seth, who will introduce the other panelists. And I think it's going to be a really interesting evening. Thank you so much.
Well, thank you, Jill, and good afternoon for everyone. I guess we're still in the afternoon, although you're going to miss your dinner if you haven't already had it, I think. It's always a pleasure to come back and deal with these bar functions and to see all of you young folks here, because I think I am the senior surviving ex-president of the county bar, and it takes a few years to do that. And you always, you wonder when you come back to these things, you're doing the same thing you were doing 30 years ago, 40 years ago, whenever it was. The mention of the appellate bar, the appellate committee operation, we started that when I was on the Board of Governors. And it was something we worked at. My wife and I still primarily spend our time working on the appellate law. And the mention of Sam Williams, there was no finer guy ever to come along. My partner, Chuck Beardsley, and I went out deliberately, and if you excuse the racial implications, we decided it was time Los Angeles had a black lawyer on Spring Street. Deliberately went out and found one of the greatest guys. There were several, a whole bunch that we could have hired. We hired Sam Williams, and of course he was with us until his unfortunate early death, but a marvelous guy, and he did a great deal for this bar association. Well, welcome to all of you. It's a pleasure to be here with all of you and with 5 such distinguished speakers. We're going to discuss one of the most prominent, high-profile, recent celebrity cases around. I suppose that and the Simpson cases are the 2 that rate way above anything else that you might have heard of. And actually, several of these people here have been involved in both of them. I don't think we could possibly have a better group of professionals to tell you about these 2 cases. Stop and think for a moment. So far as the criminal trial is concerned, we have the judge, and we have the defense lawyer and the prosecutor. You can't match that anyplace else if you're going to talk about this case. For the first case, the sexual harassment case, we have the two lawyers who were involved in that and who eventually settled it. Carl Douglas over there and Larry Feldman next to him. They get along very well, incidentally. They're good friends. So I do want to pass on and my thanks and many kudos to David Pasternak, because he did negotiate with each of these people to get them to set aside their busy schedules and to come down here and to present this program. And I think you'd have to agree they are indeed the first 5 people that you would think of if you wanted to have such a program. Well, it's my pleasure to introduce them to you. Most of them, all of them are impressive. Most of them are well-known leaders in their field, and they have all had a tremendous amount of experience, particularly on the kind of problems that we're talking about. High-level, high-profile, dealing with press, media, how do you deal with the crowds, and how do you deal with the problems? I'm going to introduce the speakers to you in alphabetic order. So that's not necessarily the order in which they will appear here, nor indeed is it the order in which they will appear in the dramas that they're going to tell you about. But it's how they come alphabetically, and I can't think of a better way. First of all, at the far end is Carl Douglas. Carl's in private practice now with his own firm, the Douglas Law Group in Beverly Hills. Each of these people have so many honors that I'm really not going to tell you about them, but he's been Attorney of the Year for various things and various other things that he has accomplished in the past. Been Lawyer of the Year. You may remember the Lauren Miller Award from the John Langston Bar Association. I'm always happy to mention the Langston Bar Association because when I was president of the county bar, I negotiated with them at some length to get them to join and affiliate the county bar. Perfectly good reasons they had for not wanting to deal with the county bar because the county bar hadn't treated them very well in past years. But we did work it out. They did join, and I'm happy to tell you ever since then I've been an honorary member of the Langston Law Club. Enjoy that. The thing that brings Mr. Douglas here is that he represented Michael Jackson in connection with that first sexual harassment case on which Mr. Feldman was on the other side, and he and Mr. Feldman will tell you about it. But he also was the managing partner of the Johnny Cochran law offices, and he was responsible for organizing, maintaining, and cooperating with and getting the dream team that represented O.J. Simpson in that case. So he's had the experience on both sides of these very high-level cases. He's particularly interested and will tell you about the unusual problems that are caused by the high media coverage of these cases, the frantic coverage, really. And it just happens alphabetically Mr. Feldman comes next. Mr. Feldman has such a spectacular record that I'm a little embarrassed to tell you about it when it compares to some of the rest of us. But nonetheless, I see a bunch of dollar signs here, and I think maybe there was something I should have passed on to you. The dollar sign, these are dollar signs that he's put in other people's pockets. Perhaps a little of it fell off along the way in his. But before we get to the dollar signs, I really ought to tell you about Mr. Douglas. Because, let's see, in 1980, no, the date's wrong. 1999, he got the largest individual verdict for a personal plaintiff injury ever in the United States. Up to that point, it's probably been exceeded since. But it was a modest $4.9 billion. That's a B I'm telling you about, $1 billion. So not bad, Carl. I've looked at some of the cases that Mr. Feldman has handled. He's done the same. You know, here's a $156 million there and $28 million, $50 million here. But I didn't see any billions. He may have one. He hasn't told me about it if he had $1 billion somewhere.
That's why I'm still working.
He has a spectacular record. He's been named as one of the nation's top 10 commercial litigators and all sorts of things of that kind. He's tried many large cases with great coverage, and so he's had the kind of experience we want. You have their brochures, and you can look at them, and that's why I'm not giving him any of the details. Next in alphabetical order, and next to me here, is Judge Rodney Melville, who was the judge in the criminal case. And a nicer, gentler man you'll never run into. He retired in 2007. 1907 was a little before his time. He retired in 2007, but they didn't appoint a replacement immediately, and so he stayed on the bench really until last year. He's had all sorts of awards, as these other people have, in connection with his job, his recognitions of things he has done for the judicial system, and he was instrumental in establishing the court's first substance abuse treatment court. And then he's been honored for his work in developing mental health treatment through the courts and being aware of those problems. All those people aren't usually aware of it. Next, alphabetically, we have Mr. Thomas Mesereau. Thomas is the very handsome-looking fellow with the hair. I'm envious of that hair. We just didn't quite manage that someday. Harvard graduate, Hastings graduate. Hastings and the judge Tom and the judge are both from Hastings. You have seen him in the paper many times. He's handled so many big coverage cases, and you've seen a lot about him. A couple things besides his best lawyers, criminal defense lawyer of the year, etc. The thing that impressed me about him that I thought you'd like to know is that he's been very vigorous in his pro bono work, and for the past 12 years, this is in your CVs, but in the past 12 years, he has defended at least one death penalty pro bono case in the Deep South. Now, that takes a lot of sacrifice and a lot of injury, but 12 years, 12 death cases in the Deep South. That's a remarkable contribution, Tom, and we're impressed by it. He was, of course, the defense lawyer in the criminal trial. Next, we have Ron Zonen. If you looked at his picture and look at him, you were talking about this early on, you will notice that when they took his picture, they had the wide-angle lens for some reason, and it shows him about twice his handsome self as he now is. So take a look at him and not necessarily at the picture. He is the Chief Deputy District Attorney in Santa Barbara. He first began practicing in San Bernardino and then went in the prosecutor's office and then went to Santa Barbara, where he has stayed since. Again, he has awards as trial lawyer or judge of the year, and that's prosecutor of the year and that sort of thing. He is now the chief deputy in charge of Vulnerable Victims Unit, where he supervises the prosecutions of all cases in Santa Barbara involving child abuse, sex crimes, abuse, and domestic violence. So he has a tremendous record and a tremendous amount of accomplishment in this area. Now, you can see why it would have been difficult to find any panel anywhere who has the kind of accomplishments and experience and reputation of these five gentlemen who are going to talk to you about these cases. Now let's move on to their presentation. I suggest that you do keep your cards ready for questions, because we will look at those and then have a chance later on, probably after the brief, to do it. And so that's what your cards are for, and use them when you need to. Now at this point, we thought it would be helpful if we have some presentation to tell you about the two cases involved, what the relationship is, and how it happened. But we thought maybe first we ought to take a look at the problems a judge has in dealing with high celebrity cases and what he does. So first of all, I would like to present to you Judge Melville, who will talk about that, and then Mr. Feldman will talk about the two cases.
Thank you very much. Good evening, everyone. Thank you for the invitation to come down and speak to all of you. I appreciate it very much. For those of you who don't know, Santa Maria is a small town located in the most northern part of Santa Barbara County. The county is divided geographically by a mountain range. Santa Maria is 85 miles north of Santa Barbara and is generally known for its vegetables, strawberries, and more recently, wine grapes. Highway 101 is the main corridor and does not pass through the town, but merely passes by it. Michael Jackson's ranch is located in Santa Barbara County, north of that mountain range. For the purposes of filing lawsuits in Santa Barbara County, there is a local rule that is inviolate. That rule is, what happens north of the mountains stays north of the mountains. This explains why People versus Michael Jackson was tried or filed and tried in Santa Maria. The case was assigned to me shortly after the complaint was filed. There had been a lot of speculation about the number of people, both fans and supporters and reporters, who would show up. Representatives of Mr. Jackson at that time estimated there would be 10,000 fans, and news reports said that there would be 300 satellite trucks descending upon our courthouse. Fortunately, these estimates were grossly exaggerated. Still, on some days, there were over 1,000 fans or public at the courthouse, and even the 10 to 15 satellite trucks that did show up seemed to dwarf our small courthouse. Now, the event that really grabbed my attention was the simple filing of the complaint. That was done on December 18th, 2003. Mr. Jackson was not present. His attorneys were not present. The DA filed the complaint and had a short news conference on the courthouse steps, or I should say on the porch of a mobile home that served as one of the courtrooms. My court administrator, anticipating that there would be a great demand for copies of the complaint, prepared 500 copies so that he could hand them out after the district attorney made his statements. Well, he was overrun by members of the media. They fought for copies. They nearly crushed him. The police literally had to go in and pull him out and rescue him. It really brought home to me the need to immediately get a handle on this situation and set some rules to guide this trial. So by the time that Mr. Jackson and his attorneys made their first appearance for the arraignment on January 16th, that's almost a month later, we were better prepared. Now, immediately after the complaint incident that I described to you, where I almost lost my court administrator, I set up a team to handle this case. And the first thing that we did was we sat down and we set some goals to guide us on all of our other decisions. We agreed on the following goals. One, to be sure not only that justice was done, but that it was seen to be done. Two, to set an atmosphere of fairness both inside the courtroom and outside the courtroom. Three, to conduct all proceedings in a dignified manner. And four, not to allow the agenda of others to overrun or divert the judicial process. Now, in order to further these goals, I needed to try to anticipate the problems and the solutions necessary to successfully handle the case. The key to handling this case definitely was teamwork. The team that I set up consisted obviously of the court administrator, the lieutenant in the sheriff's department in charge of security, the supervising research attorney, and my courtroom staff. We met regularly throughout the proceedings and continued to do that, discussing each day what the problems were and how to resolve them. From the first meeting, responsibilities became clear. Daryl Parker, the assistant executive officer I described earlier, was assigned to interact with the media and the public. He had been a clerk in the LA courts during the O.J. Simpson trial and had excellent insight into the challenges of a high-profile case. We contacted other courts who were simultaneously dealing with high-profile cases, such as Scott Peterson and Kobe Bryant. They provided us copies of their decorum orders, and we adapted them to deal with the problems that we had specifically at our courthouse. These decorum orders dealt with behavior outside of the courtroom by the public, the media, and they dealt with behavior inside of the courtroom by the public, some of them attorneys, but anyone who was to touch the case. These decorum orders were subject to the contempt powers of the court. One of the things that we did immediately was to set up, or ask the media to set up, a committee to deal with them, so that there were huge numbers of people in every area of the media, and we had to have leadership there that we could start negotiating with and start deciding what to do. So we asked them to set up a committee. We called it a steering committee, and they started meeting on a daily basis. Daryl Parker representing the courts, and people from the media representing the media. We had people from every type of media, the TV, newspapers, radio, blogs, people who were writing books, photographers, a big group of people that met with us. So by doing this on a daily basis, we were able to deal with the problems that arose and reduce friction between the court and the media. After the initial shock of handing out copies of the complaint, we set up a procedure to issue credentials to the media. The process required that each individual present themselves to us, their identification, and proof of their employer and their employer's phone number. We put all of that, including a picture of them, on a badge, a credential, which they had to wear anytime they were on the court complex. We issued 2,000 credentials with representatives from 32 countries. We not only had a large media contingent, but we had a great number of spectators. The spectators also represented many different countries and interests. On the day of the arraignment, there were definitely way over 1,000 fans in front of the courthouse. There were probably that many media, and then there were some interested public just standing further back and watching. We allowed what we did is set up a seating situation in the courtroom. This is what we did. We allowed the media to agree on who they were going to let into the courtroom. I dedicated half of the seats to the media, half of the seats to the public, and the front row was a buffer that we put nobody in those seats except maybe an artist or a guest of one of the either parties or anyone who had a guest. But what we wanted was a row where people could not interfere with the attorney's privacy as they talked to each other. As for the public, we had a lottery every morning for the seats. And the seats in the courtroom, at least at the beginning, were in high demand. We did not allow any phones or cameras into the courtroom. They were checked in at the door, and they were retrieved on the way out. We did set up a media room with a closed circuit, one camera on the witness stand, where overflow media could go and watch the trial. They were allowed to take their phones into that room, but they were not allowed to power them up. However, the advantage there is that if they wanted to go out and make a phone call, they could come and go freely, and they could power their phone when they went out. The reason they couldn't power their phones in there was, again, the photographs. We did not allow any photographs. Quite a few of the media actually preferred staying in the media room as opposed to the courtroom, because once you were in the courtroom, if you left, you couldn't come back in, and you had to check your phone. So the other room became pretty popular. However, I noticed the main media, like the Los Angeles Times and New York Times, those people were always sitting in the rows because they were always watched. They wanted to see not only the reaction of the witness, they wanted to see the reaction of the attorneys and the judge, etc. So you kind of got to know who these people were. At a very early stage, I granted a motion made by the district attorney made to prohibit parties from making statements without prior approval of the court to the media. And The district attorney brought that motion. I granted that motion, and it required that whenever either side wanted to make a statement, they would have to file an ex parte request, which we would do on short time. We could even do it over the phone if we wanted. And the statement that whoever wanted to make the statement wanted to make, we would discuss. And he would have, the guy who wanted to make that, the person who wanted to make that statement would provide both sides copies of the statements, and then we would discuss it. And if the other side wanted to make a statement, they would provide copies, and in that way, that was how we handled the statements to the media. I think that it was a good way to do it. It didn't prevent statements to the media, but it did stop what I call surprise volleys from each side over, using the press to play your position. So I was quite happy with that procedure. The atmosphere outside the courtroom can best be described by showing you a few slides. I can tell you that the pictures I have here were taken by staff and do not really show the full scale of the daily goings-on, but they will give you an idea. Okay, I didn't realize the first, this is up here, right? It's right there. Let me show you a slide.
You need somebody?
No, this takes care of it quickly. I can do this. This is a group of people that showed up at the arraignment and probably showed up on other times, and they were from a church in Los Angeles, and they marched around the courthouse with that sign saying that Michael Jackson is innocent. And they had many, many other signs, and this doesn't do justice with the number of people that there were. One of the interesting sidelights to these signs was that the fans showed up every day with huge numbers of signs saying all sorts of different things on the signs. And at night, they would lay the signs down on the ground, and they would take rocks from around the courthouse complex and stack them on the signs to hold them, because one of the things I didn't tell you Santa Maria is known for is its high winds. It has a lot of wind. So they were holding their signs down at night with these rocks. Well, the sheriff's department thought they were piling rocks as weapons. And so one night, they carefully removed all the rocks. That got rid of the problem of signs. I mean, the signs all blew away, and we didn't see near as many signs after that, and I don't think there's a rock on the courthouse complex to this day. These are just examples of the type of signs and people that showed up to express their opinion. That's a rock band that showed up, wanted some sort of publicity. I mean, I didn't realize this, but if you want publicity, just go to where the media is. They don't have anything to do most of the time, so they'll talk to you and take your picture. That's a lineup for people going in to get seats on the lottery drawing in the morning. That's some of the news media and their coverage. They were just everywhere. Here's someone who showed up because, again, I know he's passed away now, but at that time he was able to get a lot of TV coverage by showing up there and talking to him. Here's an attorney. Here's an attorney. And Reverend Jackson came, and he spoke at length, and once again, he knows, I said, what's Reverend Jackson doing here? Well, the cameras and the news media had nothing to do, so he knew that, taught me something, and he was able to speak about a lot of things there. This lady, I'm not sure why she was there, but she refused an interview with the camera and the TV because she said it was beneath her dignity. Free veggie burgers. She was quite popular with the staff. This lady was writing a book, which I think the name of it was "These Are My Private Parts." Right next to her was another judge's courtroom who was not involved in this case, and he was trying to conduct courtroom. And you notice, well, you can't see it, I guess. She had an electric microphone, and she and a friend shouted through the electric microphone, "These are my private parts. These are my private parts." And yeah, I didn't even, you have to understand, I didn't see this stuff. I'm showing it to you now, but I was not watching it. This judge that was trying to run his own court had to go out and take care of that problem or have his bailiff. And then this man danced up and down the street, and that, you know, there were several religious groups who came up, and they weren't just standing there showing their signs, they were singing and chanting, and that's another one. Now this fellow, I have no idea. There were allegations in this case that Mr. Jackson put wine in Coke cans and called it Jesus juice and gave it to the children. And, you know, it's a wonder he wasn't crucified. This is the arrival and departure. And this is the arrival, the cavalcade of cars, and then the departure was the same, of Mr. Jackson and his group. This is a picture of the jurors that I'm going to tell you a little bit about later, that no one could take their pictures, no pictures in the courtroom, and this was an artist showing the jury. This is the actual courtroom, and I'm going to tell you a little bit about that in a little bit. And this is just, again, the media, and this is the final slide, and I have permission from the Los Angeles Times to use this slide. But this is our courthouse, and this is how the satellite trucks lined up, and the media was all over in there, and that's how the cars came in and out, and the courtroom is right where it says Building G, basically. So that's all I wanted to show you on the slides. And the complaint was filed on December 18th, 2003. The trial convened about 1 year later on January 31st, and the verdict was returned on June 13th, 2005. In between the arraignment and the verdict, a lot happened. There never was a preliminary hearing, as the DA took the case to the grand jury, and Mr. Jackson was indicted on April 22nd, 2004. Between the arraignment and the indictment, there were motions filed and hearings primarily relating to discovery issues. But immediately after the indictment, on April 26th, Mr. Mesereau substituted in the place of the previous attorneys, Mr. Garagos and Mr. Braffman. Now, California Rules of Court, Section 243.1, sealed records, provides the procedures and requirements for sealing court records. The rule requires that the judge balance the defendant's right to a fair trial and the public's right to know. There were a series of pretrial motions filed by both sides, and some motions filed by media organizations. I ordered the motions and the accompanying declarations filed under seal. Proposed redactions were required to accompany the motions. The purpose of ordering the documents filed under seal was ultimately to ensure a fair trial to both sides. The alleged victim and other minors involved in this case were entitled to privacy. The jury, Benari, needed to be isolated from untested information before the actual trial. The case had to be tried in the courtroom where the declarants were subject to cross-examination and governed by established rules of evidence. Santa Maria has a small jury pool, and the media coverage, as you know, was very intense. Where could one transfer the case if a change of venue became necessary? I remember seeing a cartoon at that time with two lawyers looking longingly at the moon, saying to each other, I wonder if they could get a fair and impartial trial up there. On another level, we sought help from the Judicial Council. There were huge numbers of motions and declarations through the pretrial hearings. It totaled thousands of pages, and the clerk's office couldn't possibly handle the large demand for copies of everything that was filed. So we made application to the Judicial Council to have them amend a rule that already allowed electronic access to civil cases. We wanted that changed to allow electronic access to this particular criminal case and other unusual criminal cases. In a highly debated session, members of the Judicial Council voted 9-9 on this rule. This required the Chief Justice to break the tie, and he voted to allow us to have this new electronic rule allowing unusual criminal cases to be displayed electronically. Without this rule change, we would have required at least 2 or 3 more clerks and certainly more sophisticated copying information or support electronics. So to this day, whenever I see the Chief Justice, I thank him again for breaking that tie vote. Security measures played a very important role in this case. Everyone who entered the courtroom was searched by electronic screening every time they entered. They were required to check their cell phones at the door and pick them up on the way out. There were bailiffs all over the place. They conducted the screening, and there were always several of them in the courtroom. When the trial started, we conducted court from 8 a.m. to 2 p.m. There was no lunch break, but there were several restroom breaks. The media dubbed this the Melville Diet and proffered the opinion that from a well-known nutritionist that it wouldn't cause you to lose weight, it would cause you to gain weight. And he was right. We all gained weight. Under this schedule, 8 to 2, we were able to get a full, at least 5 hours of testimony and evidence every day. And those of you who are trial lawyers will recognize that getting a full 5 hours of testimony in any courtroom going, the normal hours would be highly unusual. So this really worked for us. And the point of the schedule was twofold. One, it allowed only one coming and going. And you have to realize that there was a huge uproar whenever Mr. Jackson and his attorneys arrived at the complex, and another uproar when he left the complex. And those things are time-consuming, and by narrowing it this way, we had, as I said before, only one coming and going. The other thing was that there's weapons screening, and so if we took a break, the breaks that I told you about for the restroom, nobody left the screened area, so there was no double screening. They went to the restroom, came back, but if we'd broke at noon or whatever, we'd have had to have screening again. So it really saved us a lot of time to run this schedule on this day, this time scan. It also allowed the attorneys the afternoons to prepare, and I don't know really how they felt about it, but I really used that time it was extremely important to me to have those afternoons, because the attorneys in this case filed a lot of paperwork, made a lot of motions, and required a lot of time for all of us. The research team was led by Jed Beebe, who is now a judge on the bench in Santa Maria, and he had an assistant and 2 interns. We had a lot of applications for interns that year, and they would read everything that the attorneys for the 2 sides prepared, and then in the afternoons we would conference and do further research and try to get to that motion the next day for oral argument. I think you've asked that we wait for jury selection, and that was the last part of my presentation.
Yes, let's do that.
All right. There's one other thing at this point I want to say, and that is that I would be remiss if I didn't mention the attorneys in this case, because both sides were represented by the most skillful and ethical advocates. If it were not for their professionalism, this case would have had a considerably different face. Thank you.
Well, thank you, Judge. It's most interesting and answers one of the questions I'm going to ask later on. And that was, in the course of all of this, did we learn anything? And it's pretty apparent that having a careful judge, thoughtful staff, cooperative lawyers who really work at it, that you really can learn and did learn a great deal about how to handle a complex case like this and how to do it the next time, building on what had gone on before and what was done here. And now, you know, you have quite a bit of material that you could work with. You have a great resource here in the judge on how to handle these various problems. I had one question, Judge. It's really two, but it's two questions, but it's really one. How many seats were there in the courtroom for the public?
I don't really know. Roughly, say 35 to 40.
Mm-hmm.
Is that?
I don't hear any dissent over here on
Yeah,
the other
that's
side.
and I think
Judges usually, lawyers usually don't dissent.
and the media had an equal number.
Yes, all right. And then in addition to that, you had a media room. How large was the media room?
It was our court likes mobile homes. It was a large mobile home, and it held all of the media representatives that wanted to be in that room. No one was turned away from that room. I had some pictures of that, but in deference to them, I didn't want to show you how they look when they're relaxed.
or with what they were drinking, I'm sure. Any other members of the panel have a question they'd like to ask now? Larry?
Judge, when you muzzle the lawyers in a high-profile case like
I resent that word.
well, we had the same issue in the first Jackson case, and the judge went the other way on it. The concern from a lawyer's standpoint in a high profile, if you're against the celebrity, is they have, like the Reverend Jackson, all these spokespersons out there who get on the news media and talk about things they really don't know what they're talking about, but they do talk about them. And how did you come out? You said you muzzled them, but did anyone raise that, and what was your thoughts about it?
Well, you said I muzzled them. Here's how it happened. The district attorney, who had been the first to fire volleys having press conferences, and I use the word volley just to say they're out there in the public making statements. And the second also was the side that brought the motion to control the press releases, so to speak. Mr. Garagos was the attorney of record at that time and is an expert. If he's here, I use that word, I mean kindly. He is an expert at using the press to his advantage. I mean, he is known, and I saw it, very good. So he opposed my motion. In fact, he may have even appealed, may have sought a writ to do that. Now, the thing that I want to say to you here is this, that when they made application, they got access to me immediately. On every occasion, the statements were allowed. There was never an occasion that the statement was not allowed, the request. But what happened was it was discussed. It was, I think, came out in a more professional statement, and the other side was also allowed to present a statement then. So my view of it is it served more civilly, as a more civil way of handling it. Now, let me say this one final thing.
No doubt you're doing that. The material submitted would have been self-censored beforehand, so it would be much better.
And there's one thing, one further mark I want to say is, at no time I served on the bench for, 21, 22 years. At no other time in my career did I issue a order of that sort. So this case, I just think, called for it.
Any other questions? Yes, Carl.
A question. Given my experience with the O.J. Simpson case, I wonder, was there ever an effort by either side, or by the defense primarily, I would assume, to have this trial publicized? Was it ever discussed pre-trial? Televised. I'm sorry, televised.
The media asked to televise the trial.
But did any of the parties ever have an interest in doing that?
No.
I'm not surprised by that.
And why aren't you surprised?
Well, it's been my experience that after 9 months of a televised trial in the O.J. Simpson case, few lawyers and probably fewer judges would want to duplicate that experience again in their professional lives. I don't know.
Now, we'll accept that as live testimony.
Absolutely.
All right, thank you very much, Judge. We'll be back to you, and we'll talk about some other problems with you. Let's move on now to a little more general background about the two cases, and Mr. Feldman will tell us about that.
You want me to do it from here? What do you want?
Whichever you prefer.
I don't care, whatever everybody wants to do. Huh?
All right, for the audience, how many want him up here?
Good evening. I had the privilege to represent two young, keep going, two young boys, both who claimed they were molested by Michael Jackson. They had some similarities that even though they were 10 years apart, that's worth pointing out, and some differences about those cases that I think are worth pointing out. Bearing in mind, it was civil. And in one, the first case, I actually litigated that case and went through the same stuff as Judge Melville has talked about and fought with about the same issues. And I'll get into that when it's time to talk about that. And in one case, we didn't really litigate it because the criminal case went first. But both boys had this in common. They were 13 years of age. They were pre-pubescent young men. Both of these boys came from broken homes. Both of these boys lived with their mothers at the time that the alleged molestations took place. Both of these boys came from homes that their mothers allowed them to spend an inordinate amount of time with Michael Jackson, alone. Both of these mothers allowed their boys to sleep over Michael Jackson's house, in the bedroom, in the bed that Michael Jackson slept in. Both of these parents, mothers at least, received things of value from Michael Jackson during the time that they had this relationship with Michael Jackson. Another thing I just thought of that these cases sort of had in common, although 10 years apart, none of the lawyers, I guess except Ron, were the original lawyers in the case. In the first case, in the first young boy case that got settled, that case he was first represented by a lawyer by the name of Rothman. He was then represented, maybe we should flash her picture on. Gloria Allred had him for about 24 hours, 36 hours. Held her press conference, and that was the end of Gloria, with all due respect. And then I had him for the balance of that case. And originally, Michael Jackson, in case one, was defended by Burt Fields and Howard Weitzman. And then ultimately they were, well, at least Bert was substituted out, and Johnny Cochran and Carl became the lawyers primarily for Michael Jackson. And in the criminal case, originally Michael Jackson was represented by Mark Garagos, as the judge alluded to, and Brafman from New York, and then ultimately they were substituted out, and Tom Mesereau came in. So we all were sort of dealing with matters that some of the cards had already been dealt with us. But they differed in a lot of respects from at least my perspective as the lawyer. In the '93 case, by the time I was retained, this case was the lead story in the LA Times. This case was in every local television newscast. It was the lead story. This case, the young boy, just to refresh some of your recollection, was sent to Children's Services through a psychiatrist that he had reported this molestation to. And and Children's Services, most of you probably know, this is a confidential report when anybody reports molestation. Psychiatrists are required under the law to report, and they are supposed to remain totally 100% confidential. Somebody got a hold of it, somebody leaked it to the press, so the press had it by the time there was any lawyers involved in this. The young boy in that case, in the '93 case, had given an unbelievably detailed statement about his relationship with Michael Jackson, how that came about, how the sexual part of it came about. He detailed in great detail the start of the relationship, how it transgressed into more physical activity with Michael Jackson, how it became fondling, how it became oral sex, how it became masturbation. And he gave this whole history in exquisite detail. The other boy, that wasn't true. The other boy was a young boy who had, at one time in his life, he had stage 4 cancer, and was a boy who had never really disclosed everything about the relationship, and came from a family that all was broken, came from a broken home, but that family, by the time they came to me, had never told any Children's Services, they hadn't been for therapy, they hadn't told the police, they hadn't told the district attorney. So in case 1, that case was sort of out there by the time we got involved. And in the second case, it had not been told to anyone. And so there were totally different issues that were involved in both cases. In case 1, the district attorney at that time, because the primary allegations were in Los Angeles, that district attorney at the time, Gil Garcetti's office, was very content to see us take the lead in that case on the civil side. And he was happy to watch us go forward, take the lead, see where what the case was about. He would have access to all our discovery, and then decide whether he wanted to prosecute the case. In the second case, it was just the reverse. The district attorney in Santa Barbara, who ultimately got the case, insisted that the criminal case take place. So first, and that there be no civil case, and that the civil side of the case take a back seat, and they, rightfully so, wanted to control the case and how it would be tried and what would be tried and how it would be dealt with in the press and elsewhere. And so there was totally different things going on. The kinds of decisions that I made in the first case, I wasn't making in the second case. The district attorney was. How this case would play out was the district attorney's choice in the second case, where in the first case I had the total control of how it was going to play out. And the reason I asked the judge the question about how he determined what to do, when we took on the first case, it was amazing to me. I mean, I had had cases before where the media was interested in it. And it typically, if you filed a lawsuit, the media might report it, and if you tried the case and got a verdict, the media would be interested in the verdict, and you'd talk for 20 seconds. But nothing was like Michael Jackson 1 at the time. There wasn't cases like that. I remember Johnny Cochran saying when we walked out, when we ultimately settled the first case, he had never seen so many press in his entire life around the Santa Monica courthouse until the next year when he tried O.J., and all of a sudden the press in Michael Jackson seemed small compared to the press that the O.J. case garnered up. But it was amazing to me how you had to deal with this press. There was a poll taken, I'll never forget, the Gallup poll did a poll about Michael Jackson and how many people in their poll had heard about this case and the allegations. And 98% of the people polled had heard about the case. Like 66% of those people believed Michael Jackson was factually innocent, and 12% believed that Michael Jackson did this to the boy. Now, for a trial lawyer, this is real issues that you have to deal with. I mean, this isn't some, just forget it, we're going to have our day in court. This is something that you're confronted with, because no matter what the jurors say, those jurors have read about it, they are deluged about it. We had, our case was on a fast track to get tried. It was going to get tried while all this was in the press. And so it's a real factor that a lawyer has to consider. And how I would watch on television with my mouth open, where people, real prominent lawyers, would be on television on the Today Show, on ABC, talking about this Michael Jackson case, and they had no idea what the facts were, what they were talking about, except that they were talking, and they were very happy to be talking. And we had to confront these kinds of problems and do it in an ethical way. Whereas in the second case, as the lawyer sort of behind the scenes, that's really where I was. I was behind the scenes. I wasn't controlling the press. I suspect I probably knew about this order, but it didn't really impact me, or maybe it did at the time. But, I was really not very involved in what was happening. And if, in fact, there was a conviction, then maybe I would have been involved, maybe I wouldn't have been involved. But it was a totally different set of circumstances. And the reason it's all so important, because at least and I'm sure it happened in Michael Jackson 2, we'll call it for the time being, but in 1 you had Elizabeth Taylor on television talking about how innocent Michael Jackson was and what a shame it was. You had Michael Jackson canceling a worldwide tour. This is the king of pop, and he is canceling a worldwide tour. I think it was the Dangerous tour at the time, because he was so upset about what this little boy was doing and so fragile. You had Anthony Pellicano, who in those days was not in jail, but he was the spokesperson. He was the spokesperson, which I'll never quite understand, that was chosen by the defendant to talk about this case. And he was someone who, in these press conferences, was conceding that Michael Jackson slept with children, with little boys. So for a plaintiff's lawyer, like I was and am, generally, that's a lot of ammunition that you have. And the question is, how do you use that effectively? And on the other hand, they were claiming there was extortion, that the father of the young boy was trying to extort money by trying to get money for this. And so that was out there. In fact, there was a criminal investigation about whether there truly was extortion. Geraldo, remember Geraldo? This is how old this is. When Geraldo did a mock trial, this is all at the time that I've come into this case, in which they're trying Michael Jackson, and lo and behold, he won, the case. So, you can't voir dire enough of jurors to how to overcome this. And also, from just a standpoint, and all of us who represent individuals get this in spades, and that is, you have a 13-year-old boy, and whether it happened or it didn't happen, their lives are in the balance of all this. It's not just about money. These kids go to school. These kids have friends. These kids at 13 years old, boys at 13 years old, are going through a very difficult time in their lives. They're trying to figure out what they are, what they're about, their sexual well-being, what that all means to them. And here it is, these most sensitive issues are in the press, and it didn't take long. I don't know so much about the second case, but in the first case, for sure, every kid on the west side of Los Angeles knew who the plaintiff was, even though the plaintiff's name at that time remained secret. So as a lawyer, you have this real burden, besides trying to make the case come out right for the client, to think about the ramifications of this, whether you really want to take on the king of pop, as it says in the program, whether you really want to be branded with this, because no matter how it comes out, you are going to have people who believe it to be true no matter what the verdict, and believe it to be untrue no matter what the verdict. So, and all you're going to have at the end of the day on the civil side is perhaps money. In the first case, it was simple, because this boy was being chastised and couldn't survive under the circumstances that existed with all this leaked. In the second case, you had a boy who had terminal cancer at one time, who was diagnosed of terminal cancer, at least, had stage 4 cancer. And here this kid has now got to decide, and his parents have to decide whether or not they should do anything about this, whether they should go to the police, whether they should go to the district attorney, whether they should go to children's services, whether they should ask for money from Michael Jackson and do nothing except try to get a quick settlement. There's all these kind of issues out there that these people have to deal with. And you have generally parents making these decisions who, in some form or another, were complicit in, if anything happened, allowing it to happen. So they're helping make decisions that impact these kids for life. So it is an awesome responsibility to represent them. And then when you have, if you did it just privately, which I have done many times for people, I just had a major case against the school district for a special ed teacher who was molesting these special ed kids who couldn't even talk. And we kept it quiet. We kept these kids out of the press. There wasn't any of this. But terrible issues for these kids. And then you compound it by a press and a news media that is 24/7, then you have a serious issue if you care about kids and you care about results. I don't know how much more you want me to go into. I can,
Let's have a
I
little
can stop.
discussion. Let's have a little discussion.
Go ahead.
We were really going to get from Larry the background and the relationship between the two cases. I think he's done that. Don't wander off because your microphone isn't working. You'll need this one. Now, I think we can move to the next question, and maybe you're back at the podium again, because I think now is the time for you and Carl to tell us what happened in that first case, case number 1.
Okay, so ultimately, that case settled. I think everybody knows that. But what happened? From my perspective, I thought that was simple, you know. Believe it or not, in 1993, there was no state bar rule. There is now. There wasn't any state bar rule on what lawyers could say or not say to the press. And Tom and Carl and Ron will, I'm sure, corroborate that once you're in one of these things, your phone, you need a special person just to deal with all the phone calls that are coming in from the press. It's just, and they don't stop. It's not like you can just ignore it. You get 100 calls from one reporter hoping they're going to get the discussion. But with you, and you'll give them an interview. But so I didn't even know what the rules were. So I kind of started with, let's think about how we're going to do this, given the backdrop that I gave you with all this publicity. How are we going to get through all this? So we looked at the state bar rules, and the California had nothing on it in 1993. We looked at the ABA rules, and they had some general rules that you can't prejudice the case by any extrajudicial statement, and that seems pretty simple, and even if we don't have the rule here in California, it sounded like something that would be pretty simple to follow. And then there's a United States Supreme Court case, Gentile, that tells lawyers that they really do have a right to protect their client. It's a criminal case, but it applies in all cases that you have a right. You can't prejudice the case, but you have a right, like what they did in Michael Jackson 2, when the prosecutor gets up and says, I'm charging Michael Jackson for sexual molestation and all the charges they brought, the defense has a right to get up and say something in the press to defend them. So it's just not a one-sided barrage. And obviously that's what Judge Melville was trying to protect, and make sure both sides, at least some facts got out there. So we knew what was the sort of the media take on this, and we also were quite aware that at that point in time, there was a big PR machine out there for Michael Jackson. He had a lot at stake and a lot of money at stake, and there were lots of people invested in him coming through this unscathed. And so we had to figure out how to deal with this. And ultimately, we figured that we would do this in a way in which we litigated the case extremely hard, that we would not have to talk to the press, we would not have to go on the Today Show, but that we would embark on a strategy that allowed us to say everything we needed to say in court documents, which are public records generally. One of the things we had that, this is before Carl and Johnny got in the case, if we could get Michael Jackson to answer the complaint before the boy turned 14 years of age, we were entitled to a trial in 90 days. That was the selling point to the district attorney to give me a chance to see if we can get this under a 90-day speedy, or 120 days it probably was, 120-day speedy trial. Filed the complaint. They answered the complaint for whatever reasons, and then we filed a motion right away to get a speedy trial. The defense, with all due respect to them, had to worry about not just defending Michael Jackson in a civil court, but more importantly knew there was a criminal case behind this civil case, and they had to defend him worrying about his Fifth Amendment rights. Now, as he tried to fight back our motions for a speedy trial, we litigated that hard in papers. And we always paid respect to his rights under the Fifth Amendment, but we also made it clear that if he had nothing to hide, and given we had a 13-year-old child at stake, we ought to go and have this litigated. It'll be behind both of them. And the press loved it and picked it up. Every time we did depositions, if one of the employees, and we took a lot of depositions in the case of people who had knowledge about Michael at Neverland and his relationship with this young boy, the minute the lawyers would try to stop him from answering a question, we would be filing documents about that and what the question was and why it was relevant and where it was leading to, and the press would run with it and love it, and there'd be declarations. When we wanted to have an exam of Michael Jackson, and take pictures of Michael Jackson, because the young boy made allegations about his physical parts, his private parts, as you saw, we had to describe them in detail in order to show why we were entitled to these pictures. So we litigated it hard, but clearly within the rules of litigation. And it almost didn't matter whether we won or lost. The fact is we were getting even by all these types of things. There was a motion made by the defense, I don't recall if Carl was in it or not at the time, to try to gag the lawyers, and I took the position that gagging the lawyers doesn't solve the problem. At least with the lawyers, you do have a chance that you get an accurate report about what took place. The problem we had is, as that motion was being litigated, you had people from the Jackson family giving interviews telling how poor it was that we were suing Michael and how bad it was for Michael, and et cetera. What you'd expect family members to do. So we could control the lawyers, you could control the clients, but you couldn't control all the people who had a view. So that was the course that we took. And at some point, and it was, there was, at some point, Johnny and Carl came into the case. At some point, Johnny and I did go back a long way. I had the really distinct privilege of representing Johnny a lot of times in his life, and we were able to trust one another, along with the help of three judges who sat in on a very secretive settlement, and we were ultimately able to get the case settled and work through all the problems and all the details for the benefit. It was, and they trusted me, and I trusted them, and it was able to get settled. It didn't resolve the problem with the district attorney, whether they would bring a case, but it was pretty clear to everyone that once you go through one of these things, when you are 13 or 30 or 50, the appetite to go through it again, when you finally get some respite, some peace, whether it be in a criminal case or a civil case, is not that, you're not that hungry to do it again. And for this kid who had to live his life and was now financially taken care of, and you have a district attorney in that case who wasn't really aggressively doing anything, it wasn't that hard for him to make the decision that he had had enough of this and didn't really want to go forward anymore. So that's sort of the background of that case and what happened in that case. Michael Jackson went on to live his life, and this boy went on to live his life. And that's pretty much what happened on the case, the civil case in 1993.
You can take this one. You're still entitled to another word occasionally. Pardon me. Now we'd like to hear from Carl, who represented Michael in that case, as well as in various other matters, about his versions of what happened, and particularly his views on how you really defend the king of pop, how you deal with all of this press, how you do it in an ethical manner, and how you try to get a fair result for your client.
Thank you, Seth. I want to first thank Seth and David and Harry Hathaway for having this panel, and I thank all of you for coming out and being a part. I was a part of one of these Frozen in Time talks last year, so it's a pleasure being invited back again. I want to take you back to 1993 to really appreciate and understand the dilemma that we faced as lawyers. 1993 was before the internet, before YouTube, before TMZ. It was before what has now become known as checkbook journalism. The British press are relentless, and their relentlessness was no more greater demonstrated than with the zeal with which they pursued the Michael Jackson matter. In 1993, I was a 38-year-old lawyer who had experience both in the criminal and civil plaintiff arenas. I was working for the sixth of my 12 years for Johnnie Cochran, who was at that time the man here criminally in Los Angeles. Mr. Cochran was known for having a unique blend of skills. He had represented several high-profile criminal and civil cases in the past. He had successfully defended an actor, Todd Bridges, a few years before, and he had made his name in the police arena back in the early 60s, defending or representing the family of Ron Settles, who had been killed by police in the Signal Hill Police Department. So Johnnie Cochran came to Michael Jackson with a unique skill set that he found very appealing. We were first retained in that case in December of 1993, and that was the lowest point of Michael Jackson's career up until that phase in his life. As Larry suggested, he was on the Dangerous tour. He had been touring in Europe, and because of some health problems and concerns about this case, he had had to cancel that tour with these allegations swirling around him. He had also, right before we had been retained, had secretively checked into a treatment program to deal with some prescription drug issues, which really became more relevant in later years surrounding his death. And at that time, there was a joint criminal investigation, as Larry described, not only being conducted by Gil Garcetti in the district attorney's office, but also by Tom Snedden, one of Mr. Zonin's colleagues in the Santa Barbara DA's office as well. And at that time in December, a few weeks before Christmas, Michael was basically afraid of returning back to the United States because he feared if he did, he might be arrested, and that would have been a death knell to Michael Jackson and his entire world. At that point, he had been represented, as Larry said, by Bert Fields, who was a well-known entertainment lawyer, by Howard Weitzman and his firm as well. And Michael decided to retain Johnnie Cochran and his firm to assist, basically to replace Bert Fields' office, because they thought that the skill set that Johnnie and his firm brought to bear was consistent with both the civil and the criminal allegations that he was then being confronted with. And I remember initially there had not been any effort by any of his lawyers to contact the district attorney's office to see if there were charges pending, if they were going to arrest him, or what was going to happen. And the first thing that Johnny did when he was first retained was to have a conversation with Gil Garcetti. One thing about Johnny was he was well connected in Los Angeles, both in front of the scene and behind the scene. And back in the early 80s, he had been a colleague of Gil's under the leadership of John Vandekamp. They were old friends, and that friendship was something that he was able to draw on to call up Gil to see if there was ever any fear of Michael returning back to Santa Barbara. And when he told there was not, there was then this celebrated return to Neverland, which is a fabulous place. I'll tell you about it later. And that is basically how we began to embark on that case. One of the thrills of my life as a 38-year-old guy, and I was maybe 4 or 5 years older than Michael at the time, was to meet the King of Pop. I had all of his music. I was a big fan, and it was a thrilling occasion just to have the opportunity to work on his particular matter. Michael and I developed a particular affinity for each other. I was one of the first African-American professionals that he had ever retained. And because he and I were close in age, we kind of bonded. And because I was the managing lawyer in Johnny's office, and I had a blend of both criminal and civil experience as well, I was assigned the task of primarily being Johnny's right-hand man working on this particular case. I remember sitting in private negotiations with Larry and 3 judges trying to work out some resolution to this case. I remember the sage words of one of the judges that it's not about how much this case is worth, it's about what it's worth to Michael Jackson. And ultimately, that was an argument that had resonance as we kind of bandied about some extraordinary numbers for 1993. The numbers were extraordinary for even 2010. But in 1993, they were really some fabulous numbers that were being bandied about. I remember traveling to Las Vegas and the Mirage Hotel in January of 1994 because I was the one that presented the settlement agreement to Michael. He was staying at a bungalow there, and I remember I knocked on the door, and he said, "Hello, who's there?" And I say, "It's Carl." "Okay, hi, Carl, how are you?" And I remember I was the witness for his signature on all of the lines of the settlement agreement. And after that case was resolved, our firm continued to work as his personal lawyer basically through the beginning of the criminal trial. I remember that we were present for some other trials that he was engaged in because once there was the initial matter of Jackson 1, there were litigants that came out of the woodwork everywhere, left and right. I remember that we were involved working on his divorce with Lisa Marie Presley, which is a whole nother seminar I could tell you about. I remember that I was involved with decisions about transitioning from Mark Garagos, who was then representing Scott Peterson, to Benjamin Braffman, who was a lawyer from New York. And by that time, in the early 2000s, Johnny had moved to New York. And I was not clear, because I had left his office some years before, at how sick he had become by then. And he basically used me as a surrogate to try to persuade Michael to transition from Garagos to Ben Braffman. I remember being concerned because Scott Peterson did not seem to be a very winnable trial. And I was fearful that if Mark Garagos continued as Michael's lawyer, throughout his trial, his lawyer would be referred to as the lawyer who represented Scott Peterson. And I thought that was a terrible tag that would always hang on his defense throughout the pendency of Jackson 2. So I was very happy when decisions were made, not only to transition from Garagos to Braffman, but then to transition from them to Tom Mesereau. And I can remember recommending Tom Mesereau as someone with whom I had tremendous respect over the years and who I thought would be able to do a suitable job on his behalf. In terms of Jackson 1, Larry is tremendously accurate when he talks about the respect and the trust that Johnny and Larry Feldman shared among themselves. He's also correct that the decision that was hotly contested in terms of having a trial in that case set in 120 days was a devastating tactical loss for our team, and it was significantly powering efforts to try to resolve the case. This entire experience was one that I will certainly take to my grave. I was one who, because I was one of the more junior lawyers, would be given the kook role. And so when we had to hire another secretary just to act as a receptionist, I had several conversations with a woman who swore she was Billie Jean. And the child is hers. But there were all kinds of not only kooks, but soothsayers or people that claimed to have important information, and all of those potential leads had to be vetted, and yours truly was often given the first obligation to go forward and to try to figure out where the truth lie. In our case, at least once Mr. Cochran became involved, there was never a discussion of a gag order. I worked for Johnny for 12 and a half years, and he never shied away from a camera or a microphone. So that was something that was considered well before we became involved in the case. Representing someone who is of the acclaim of Michael Jackson is a tremendous, tremendous burden. For me, it heightened the importance of trying to do a job well, because I knew that anything that would be done would ultimately be scrutinized by lawyers and talking heads across the world. Tabloid journalism was a tremendous concern that we had in those days. This was, in fact, one of the first high-profile cases, and Larry talks about the scene that took place on January 25th of 1984. That was the day that the settlement of the Michael Jackson matter was going to be announced. In fact, I was able to find some statements in my records of both a version of the facts that Larry was going to read, that all parties signed off on, and there was a version that Johnny was going to read and all parties signed off on. There were probably 15 or 20 satellite trucks. There were 50 or more members of the media. Whenever you see those scenes, you'll see my head sticking in the back right between Larry and Johnny. And I'll remember always the scene as we were walking away from that press statement. Johnny called me son. He said, "Son, take a look at this, because you will probably never see a sight like this again." And I remember just 1 year later, January of 1995, we were driving in my car that I was able to buy after the Michael Jackson case. I had a little bit of money on the side. And we were driving around Broadway, turning right onto Temple. And there was a phalanx of reporters and media. They had police officers out there just to control the crowd. And I looked and said, "Dad, what about this?" It was indeed a remarkable experience. Working on a high-profile case both has its detriments and it has its benefits. I like to tell colleagues of mine who I speak with about the publicity, that publicity is like crack cocaine, or like I hear about crack cocaine. Because it can make you lose your mind. And I'm always instructing other lawyers that it's not all that's made out to be. It's a tremendously important possibility that can be fraught with all kinds of dangers. I remember that the experience that I had and that I drew then taught me a lot when I was involved in the mother of all high-profile cases at the time, which was the O.J. Simpson case. And the experience of having that trial televised each day became a lesson that both litigants and I'm sure judges took to heart. It's difficult having your daily work scrutinized by a camera or analyzed by people who don't really know the nuances and the subtleties of what's going on each day. I can imagine if there was a camera watching a mechanic tune an engine. Look, he's using that wrench instead of another kind of wrench instead. It places tremendous stress on you as a professional, tremendous burden on you as an individual, but it can also be very rewarding as well, because in the Michael Jackson case, at its most essence, Johnny and I were plaintiff lawyers. And plaintiff lawyers, as I'm sure anyone can tell you, enjoy the opportunity to have their name in lights or to have their faces in front of cameras and the media. It is something that we relish and that we yearn for many times. And we found that, particularly since I've had both a criminal and a civil experience, civil lawyers yearn for the publicity that criminal lawyers can enjoy, and criminal lawyers yearn for the money that the civil lawyers make. But the experience is one that I will continue to take with me, and I thank you for allowing me to share some of my thoughts with you today.
Well, ladies and gentlemen, in my 88 years, I've listened to quite a few presentations about legal issues and legal matters, and I must say the gentlemen before us have done a marvelous job and reveal a lot of wisdom and learning that we won't often hear. We've reached our point, I think, for a break. I have a couple things to say. We will come back and hear about the second Michael Jackson matter, the trial this time, and the participants in that. But for all of you, if you have questions, remember to deliver them right over here, and we will take a look at them so we'll be able to do something with them before we leave. But you know, when you're having fun, it's already 7:30, and we'll be moving along into the next trial. So we'll have a break.
You can talk about being a witness in a second.
Go ahead, sure.
Okay, if I could have everyone's attention, please. We're going to get started. I know.